This would necessarily mean that while sitting here, we are going to command the government that you, as far
I am not saying
as
that.
production is concerned, you go like this.
I am not saying that, my lord. I am not saying that. I am not even.
See,
I
our
am not
country,
seeking the court to interfere with any policy of the government.
a single nation, a developing nation or developed nation, who are not having energy through nuclear plants,
Energy,
production of power through nuclear plants.
I'll tell you, Lordship. Japan has stopped. Germany has stopped completely. Stop.
No,
They have
something.
they have dismantled all their plants, and not only that, my lord. Total liability has been capped at roughly under 4,000 crores. Though, my lord, in a nuclear accident, if a nuclear accident indeed takes place, the damage that is done is hundreds of times. In fact, in in Fukushima as well as Chernobyl, those are the two major accidents, nuclear accidents. The damage was almost 1,000 times.
It's a very sensitive legislative policy issue, Mr. Bhushan. If you provide, suppose, create such a, as you are saying, very robust kind of compensatory regime,
Yes, madam.
the technology is not available within your country.
Yes.
You have to depend upon this technology on somewhere else. Then who will come?
So, my lord, the question is this court in the Shriram oleum gas leak case, Constitution bench laid down two principles. They said that firstly, all private corporations also, which are regulated by the state, will come within the ambit of Article 12 and Article 21 if
No doubt.
carrying out hazardous activity.
That is the absolutely correct.
And second, that they will be strictly and absolutely liable for any damage that is caused by any activity which they are doing, which is hazardous in nature. Now, nuclear power plant is definitely hazardous activity. There is no doubt about that. Now, the question is, my lord, that principle laid down by Constitution, and that is why, my lord, your lordship had admitted the earlier petition filed by Mr. E.S. Sarma himself. A rule was issued on this question. Though that act, which was challenged at that time, which has been replaced by the present, this is another copy.
So that is not the point that court will admit. The point is that today there are countries.
Yeah.
There are several countries
Yeah.
who they will say on this issue
We have a
tax-free regime.
uh-huh.
There are countries you will find, like if we are imposing here 20%.
That's all right, my lord. The question is, the government can do whatever it wants by way of policy, but they cannot sacrifice Article 21 rights of citizens on the altar of policy, because here this.
Courts can always enforce so far as state is concerned. They can't run away from their responsibility.
Yes.
This
is the act.
The act is limiting the liability in the event of a mishappening
Yes.
of those who are coming to invest here in the particular project.
Yes.
That does not take away the power of the court
Yes.
as far as to compensate the state that liability.
No, Lord, the Act imposes an absolute limit of less than 4,000 crores for any accident. Only the residual liability, which would be, because the total cap on the liability of the government plus operator is less than 4,000 crores.
Suppose liability comes out 40,000 crore.
Yes.
Let us say 40,000 crore.
Yes.
The act say 4,000.
Yes.
The nation, through parliamentary regime,
Yes.
can make a commitment to an investor that look here, liability may be 50,000 crore, liability may be 1 lakh crore, liability may be 5,000 crore. As far as you are concerned, we absolve you beyond 4,000.
Firstly, my lord, the Act does not
That
do
does
that.
not, that cannot, and that does not tinker with the power of the court to determine and assess the compensation to which a victim may be entitled to.
Two things, my lord. Firstly, the Act lays down a limit for government's liability also. Second, insofar as you exempt a supplier of nuclear equipment from liability or from liability beyond a cap. In fact, my lord, in this Act, in the earlier Act, the supplier was not exempted. But in this Act, the suppliers have essentially been exempted. The entire liability of this limit of less than 4,000 crores is placed only on the operator. Now, what will happen is that the suppliers who are not going to get the bulk of the cost, and the cost of setting up a nuclear power plant is 20, 30, 40 times the cost of setting up a solar power plant of the same capacity. Today, my lord, the CERC, which regulates the cost of electricity from solar power plants, has fixed the cost of solar electricity at 3.5 rupees a unit from solar power plants. The government says that the capacity of solar power in India, even for by using 6% of our wastelands, is more than 3,000 gigawatts, more than 3,500 gigawatts. The total energy demand today is 245 gigawatts. Our capacity from solar by using only 6% of our wasteland is 20 times.
This would necessarily mean that while sitting here, we are going to command the government that you, as far as
I'm not saying that.
production is concerned, you go like this.
I'm not saying that, my lord. I'm not saying that. I'm not even.
See, our
I'm not
country-
seeking the court to interfere with any policy of the government. But that policy, my lord, cannot sacrifice.
Tell us a single nation, a developing nation or developed nation, who are not having energy through nuclear plants,
Energy,
production of power through nuclear plants.
I'll tell you, lordship. Japan has stopped. Germany has stopped completely. Stop.
No,
They have
stopping is something
they have dismantled all their plants. And not only that, my lord. In Germany and Japan, there is no cap on liability. And even in the US, the cap is more than 100 times the cap which has been imposed here. 1,54,000 crores is the cap in the US. In India, the cap is less than 4,000 crores.
So that will be the, of course, because US per capita income, the liabilities and all these things, you know,
But here also, the liability.
it will take for us some time to reach that level, whenever it will.
But the Lord, the question is this. Once this constitution bench of this court has laid down a legal constitutional principle, which is, just see the principle laid down, my lord, page 288 of the paper book, para 30 and 31. I might just read it out, my lord. It says, prima facie, we are not inclined to accept the apprehensions of the learned counsel for Sri Ram as well founded when he says that our including within the ambit of Article 12 and thus subjecting to the discipline of Article 21, those private corporations, page 288, my lord, para 30, after 5 lines, those private corporations whose activities have the potential of affecting the life and health of the people would deal a death blow to the policy of encouraging and permitting private entrepreneurial activity.
Absolutely correct. You will
Now, whenever a new advance is made in a field of human rights, apprehension is always expressed by the status quo is that it will create enormous difficulties in the way of smooth functioning of the system and will affect its stability. Similar apprehensions were voiced when this court in R.D. Shetty, etc. Now, my lord, next paragraph. Para 31. We must deal with one other question which was seriously debated before us, and that question is, what is the measure of liability of an enterprise which is engaged in a hazardous or inherently dangerous activity? If by reason of an accident occurring in such industry, people die or are injured, does the rule of Rylands versus Fletcher apply, or is there some other principle on which the liability can be determined? The rule in Rylands versus Fletcher was evolved in 1866, and it provides that a person who for his own purposes brings to his own land and collects and keeps there anything likely to do mischief, if it escapes, must keep it at his own peril, and if he fails to do so, is prima facie liable for the damage which is a natural consequence of its escape. The liability under this rule is strict, and it is no defense that the thing escaped without the person's willful act, default, or neglect, or even that he had no knowledge of its existence. This rule lays down a principle of liability that if a person who brings onto his land
skip कर सकते हैं, but it is not necessary for us to consider this. We have to develop our own law, proper judicial law. Then we talk about modern technology and then this. नई hazardous.
Then, Lord, on the next page 290, we are of the view, on the bottom of that page, 6 lines from the bottom, we are of the view that an enterprise which is engaged in a potentially hazardous and inherently dangerous industry which poses a potential threat to the health and safety of persons working in the factory and residing in the surrounding areas owe an absolute and non-delegable duty to the community to ensure that no harm results. In fact, my lord, that earlier petition of Mr. E.S. Sarma, though, my lord, now that act has been repealed, and that act has been repealed and replaced by an act which is even more dangerous, because in the earlier act, the suppliers were not exempt from liability, though there was a cap. And yet, my lord, this court issued rule and said, we will examine this question.
Bhushan,
Yes.
that may not be our concern that who has been exempted and who has been absolved or put liability.
Yes.
Our concern is that unfortunately and God forbidden, if any accident takes place,
Yes.
and if a common citizen of this country or any person
Yes.
suffers any injury,
Yes.
loss, damage of anything,
Yes.
do we have a robust compensatory mechanism for that person?
So,
If that is effectively addressed, probably your apprehension disappears.
my lord, my answer to that is, firstly, there is a total cap on the absolute liability or residual liability of the government also. Residual liability is capped under a schedule.
Through a legislative means, can the powers of a constitutional court be restricted?
That's the issue. So this act, my lord, this act is clearly unconstitutional because it says something.
It does not say that the constitutional courts can't do that.
No, my lord, what it says is, the act says that the absolute liability, if your lordship now comes to the act, just says what the act says.
We will hear you someday in detail and clarify this apprehension so that nobody should have any.
All that I am requesting is that your lordship may, in fact, my lord, in the earlier petition, rule had been issued by this court.
This also lead to, sometime we admit a matter remains pending for years together and then it becomes a very big obstacle. The only thing is that today we should clarify what is the legal position. Nobody can curtail the powers of even a tribunal for when he wants to assess the tribunal wants to assess compensation and suitably say award whatever a person is found entitled to in law.
No, the other issue is this, my lord. By exempting the supplier, lord, you are encouraging the supplier to cut corners because the cost of a nuclear power plant, my lord, runs into tens of thousands of crores. If you set up a 1000 megawatt nuclear power plant, my lord, the cost will run into 20-30,000 crores. Now, if you are saying that you will not be liable or that you will be liable only to the extent.
Two issues will arise, that are we examining to prevent the installation establishment of these power plants, or we are only concerned about that in the event of an unfortunate thing happen, that our people are safe and secure.
So, my lord, if the law
I
prescribes,
probably think that the second issue is the real and most important.
if the law, my lord, effectively encourages the suppliers to cut corners on safety and thereby, my lord, puts at risk the citizens of this country. Their Article 21 rights are gravely jeopardized by that, and therefore, my lord, in that respect, it violates Article 21 rights of the
The
citizen.
state will compensate them. If the state does that, the state knows how to
State is capped. This act caps it, my lord, unless this court
that
strikes
part,
down.
we appreciate your apprehension. So that we,
But even the other part, my lord, because insofar as you are encouraging a foreign corporation or a private corporation to cut corners by saying that you are not liable, you won't be held liable, you are encouraging them to cut corners on safety. And my lord, it has huge consequences.
Question becomes a question touching on economic policy.
No, my lord, with great respect, my lord. In this case also, this was argued. Exactly. The Sriram Oleum gas leak case, exactly this was argued by Mr. Diwan. And this was rejected expressly by Constitution bench of this court. They said, the argument was that, look, this is a private corporation. It is not subject to Article 21 or Article 12. And they said,
You need not labor on that because law today, after Kaushal Kishore, resolves that distinction between the state
that's why I'm
and
saying.
individuals in respect of Article 21.
That's why.
But when the state, in its own policy, decides to cap the liability of a private entity, we are not here to second guess the decision making of the state in its subjective
With great
domain.
respect, my lord, with great respect, if the capping has the effect of encouraging a supplier to cut corners, capping or exemption of liability.
You are now challenging a constitutionality of a legislation on motive.
No, my lord,
Don't
not
think you
motive,
cannot
not
go
motive.
into
I am
this.
saying it is bound to have,
Going to
it is
the
bound
issue
to have
whether
that effect.
provision impacts Article 21 or any one of the fundamentals.
And then there is one other major issue, my lord. The issue is the independence.
If the parliament enact a law
Yes,
with, in terms of in furtherance of its policy of FDI,
yes.
and it runs the risk that by putting that this much only maximum cap on your liability, rest country will, the state will bear, or the state will have to impliedly or explicitly bear it. It's a pure fiscal policy through a legislative means.
With respect, my lord, that's not a pure fiscal policy. And in fact, my lord, there are other issues. The
We
one other
understand-
issue is
we understand
the
your-
independence of the Atomic Energy Regulatory Board. India signed a convention which says that the regulatory board has to be independent of the agencies which are running nuclear power. Second, the CAG has also said that the current AERB is not independent of the Atomic Energy Commission or the government.
If there is some board and Union of India is not following, let the board and Union of India have a dialogue, how the courts are concerned about that part.
Because, my lord, that's part of the
Tomorrow a foreign authority try to impeach, and should we take it as a ground of judicial review for, because some board sitting somewhere have an
court.
opinion.
I'm saying that there is a convention on nuclear safety, which India is a signatory to. That convention can be read into municipal law. According to so many decisions, Gramophone Company, Vishaka, and so many judgments of this court, at least a dozen judgments of this court. Now, that convention says that the regulatory board has to be independent of the Atomic Energy Corporation as well as of the government of, as well as the government which is primarily running these things. Here, the Act provides that the Atomic Energy Regulatory Board will have a search committee which will be headed by the Atomic Energy Commission. And thereafter, my lord, the appointment will be by the government and removal will be by the government. Therefore, in that situation, what is the independence of this Atomic Energy Regulatory Board? Therefore, that is another issue in this case before your lordship. There are several issues, several very important issues. Therefore, Lord, what I am requesting is, your lordship had issued rule in the earlier matter after considering the issue on this prayer of the cap on liability. And therefore, my lord, your lordship at least issues notice in this matter, so let the government of India respond to the issues that we have raised.
Hear you, Mr. Bhushan, and some of your apprehension which requires attention, we will try to clarify that issue so that there is no apprehension in mind.
Very well, my lord. I am not
Today we have kept some matter where we want to start it on day-to-day basis. For
very well.
Item
So
9
your lordship will list it.
in July.
All right.
Second week of July, first week will be miscellaneous after that.
All right.